delighted to welcome you here to the 14th annual Peter A. Jaszi Distinguished Lecture on Intellectual Property. So without further ado, I want to introduce my colleague, Christine Farley, to get us started.
Good evening. So along with Michael, I am the other co-faculty director of our program on information justice and intellectual property law. And I am so delighted to see so many distinguished guests and dear friends. Those are not two mutually exclusive categories. And of course, there's some overlap there. Here in the room, and I know I've seen the RSVP list. We have more than 200 wonderful folks online joining us from all over the world. And we're delighted to welcome you all here tonight for this exciting event. It is my privilege and honor to be the person who gets to introduce Peter Jaszi to you. I don't need to introduce him to most of the people who are here and joining us online. No offense, Vend, but we have some wonderful lecturers and some wonderful topics, and they're not always the draw. But a lot of people are here because it's the Peter Jaszi Distinguished Lecture, and people are anxious to have the opportunity to get some rays of light that come from his brilliance, if we only get to talk to him and see him for a few moments. So we're here for that opportunity, and we're here to pay homage to Peter as well. And I, for those of you who are new to this lecture, I guess the first news blast is Peter's alive. This wasn't a post-mortem honorary lecture. And I only, realize I have to make that announcement because, especially to those of you online who haven't yet seen Peter, he's over there. I keep looking at him because some years back, we had Judge Pierre Laval give the lecture, and he was much relieved to know that when he was asked to give the lecture that Peter was still alive. It wasn't one of those lectures. I also want to welcome those of you who don't know Peter yet. And I'm really happy to see so many of our students, our current students in the room. I think well done that you took advantage of this opportunity to come to this event. And I'm always excited to share Peter with our current students, and a little bit sad that you didn't have the opportunity to have him as a professor. I regularly interact with alumni who did have him as a professor. They always ask about him and remember so well his classes. Peter, students, to introduce him to you, was an early leader and advocate for copyright law in the public interest. He has long been at the forefront of intellectual property and copyright law with a particular focus on promoting users' rights. So for those of you who are not yet in those categories of distinguished guests and dear friends, it's really a wonderful opportunity for you to have to hear a little bit about his career, which I'll share with you. And I hope that you'll introduce yourself to him in the reception afterward. He's had a major impact on copyright law. He's had a major impact on this law school, and he's certainly had a major impact on the way we teach intellectual property and the way we've developed our program. I first came to know Peter when I was a law student, and I came to know him through his article, his 1991 article, so I'm dating myself, Toward a Theory of Copyright, the Metamorphosis of Authorship. That article challenged some of the most fundamental assumptions we make that underlie so much of copyright doctrine. And it really led to decades of scholarship. It was really a forerunner in new ways of thinking about intellectual property law. And it led to many legal reform efforts. And it personally caused me to pursue a career in IP, and I suspect I am not nearly alone in that, having been influenced by something that Peter has written. He's since written numerous books, book chapters, articles advocating for copyright law in the public interest and promoting users' rights. And I want to especially draw your attention to his book, Traditional Culture, A Step Forward for Protection in Indonesia, which was a result of a long and extensive study in Indonesia, interviewing many different kinds of artists, studying the way that traditional arts there had developed in the absence of IP regulation. Since 1999, I have had the immense pleasure of having Peter as a colleague. And from this vantage point, I have been continuously inspired by him. I didn't expect that such a thoughtful scholar could also be such an effective builder of institutions and movements. Here at the American University Washington College of Law, Peter founded the Glushko Samuelson Intellectual Property Law Clinic, which, along with the Berkeley Clinic, was the first clinic in the nation devoted to intellectual property law. He was also the visionary behind our program on information justice and intellectual property law. We always say PIDGIP. I think everybody here knows PIDGIP. I'm just going to say PIDGIP from now on, which is ranked number 6 in the nation. These programs bear Peter's indelible mark and have for decades now trained lawyers to see IP not as an end in and of itself, but as a tool that must serve justice and the public interest. In the 1990s, when the internet was still finding its footing and the battles over digital copyright were just beginning, Peter was the principal founder of the Digital Future Coalition. He brought together library associations, educators, and public interest groups to ensure that the interests of the public were heard in copyright policy making. He testified before Congress repeatedly, served on the Librarian of Congress's Advisory Commission on Copyright Registration and Deposit, and became a trustee of the Copyright Society of the United States. Peter was a part of the legal team representing the National Federation of the Blind in the Authors Guild versus the Hathi Trust litigation. Peter's 2-decade collaboration with Pat Aufderheide on fair use pioneered an approach that empowered creative communities to reclaim fair use rights that had been chilled by legal uncertainty. Beginning with the documentary filmmaker statement of best practices in fair use, they facilitated journalists, filmmakers, scholars, teachers, and others. And this work helped creative communities develop fair use guidance documents that reflect their particular problems and practices. Peter's work to guarantee fundamental fairness and balance in copyright law has been deservedly recognized with several awards, including the American Library Association's Ray Patterson Copyright Award, the DC Bar's IP Section Champion of Intellectual Property Award, and the Public Knowledge's IP3 Award. Peter has had and continues to have the fullest possible career as a public intellectual and public interest advocate. He now practices in the firm Yazzie Butler, where he advises filmmakers, artists, and creators on fair use. And his IMDb page, yes, he has one, lists the many amazing film and television projects that he's consulted on. Long before Peter was a lawyer or a professor, he had a job that I think set the course, or at least would have, if we looked back, we would have maybe predicted where his career has taken him. He was, in college as an undergraduate, the manager of the Orson Welles Cinema in Cambridge, Mass. And he was, as I understand, in charge of programming, and was instrumental in bringing archival treasures and independent films to audiences. And I think you can see the same values and objectives in the work he does around intellectual property law in terms of preservation and access. Please join me in welcoming my colleague, my mentor, and one of the great champions of the public interest in intellectual property law, Professor Emeritus Peter Jaszi.
look at the room for a minute. Yeah, I can tell the story. It is a riff a little bit on Christine's 20 years, something like ago. I was at a nice meeting in New York, and a very young, and as it would turn out, very gifted and very productive scholar who shall be nameless came up to me in the hall between the sessions and greeted me. I had a name tag. Greeted me sort of effusively and went on about how much he had been influenced by something I had written or whatever. And then he looked up at me and he said, "But I thought you were dead." So I never brought that up with him in later years. I probably should have done, but I couldn't somehow bring myself. So after that, largely fictitious introduction, which is still so moving that I can hardly speak. I have my own special privilege, which is to introduce our speaker, and I want, with your indulgence, to do so in a slightly indirect way by taking you back to the days of yesteryear, to, let's say, the late 1980s, very early 1990s, and try to get a snapshot, if we can, of what the field, which we now know affectionately as TKGRF, traditional knowledge, genetic resources, and folklore, otherwise known as traditional cultural expressions, looked like way back then. And the answer was not much. It was a recognized topic in intellectual property discourse, a sort of a small stack of rather abstruse theoretical articles had accumulated over years on this topic. There had been one noble, although I think probably in many respects fruitless, effort to explore the idea of international norms in the area, that being the 1982 UNESCO WIPO model law, or perhaps I should say WIPO UNESCO model law on expressions of folklore. But as the 80s wore on and the 90s began, there was not much happening in this part of the woods. And then something changed. And I started to try to think today about why that was, about why during the course of the 90s, this topic, what to do, and especially what to do at the international level about giving legal recognition to the many forms of knowledge of which indigenous and traditional communities are the living custodians, where that impulse came from. And I think, without belaboring it, and also because I'm not sure I could prove anything I'm just saying, there was a confluence of factors, various, call them interests, call them experts, call them advocates, who had a primary interest in something else, became at least indirectly engaged with this question about what to do about old knowledge and the old arts. It became a critical issue, albeit a secondary or even tertiary one, in the drive for the preservation of cultural and ecological diversity. It became a focus of interest on the part of those of us, and I was one of them. This is when my interest in this field first attached, who were doing or felt we were doing, even though we might not have given it that name at that time, what you might think of as sort of information justice advocacy. It was suddenly of great interest to developing country governments, which saw potential value in the resources that were conserved and maintained by communities within, or in some cases across their borders. And then crucially, it became a matter of interest, even a matter of concern for indigenous and other traditional communities themselves. And it was the confluence, I think, of all of those developments in discourse, which caused a lot of people and a lot of institutions to take a new look at these issues and to consider whether there was, in fact, more work to be done. And among the institutions that made the choice in the course of the 1990s to invest resources and reputation in the issues around traditional knowledge, genetic resources, folklore, traditional cultural expressions, was, of course, the World Intellectual Property Organization. And I became aware 25 years or so ago that in fulfillment of its institutional commitment to this important topic, the WIPO had taken on a new person, a bright, extremely well-trained young South African lawyer who had a tremendously good reputation in the international IP community, who I did not know personally at that time, but about whom I heard the very, very best and most promising of things. And that person was, of course, our speaker of tonight, Ben Vendlin, who came to WIPO at that point and did over the years a series of absolutely critical jobs within the institution as, among other things, director of the division that specialized in traditional knowledge and related issues. And even though the title doesn't sound very romantic, it was a key one, the secretary of the Intergovernmental Committee for Traditional Knowledge and Folklore. And it was that secretarial capacity that then worked over years to convene a series of critical meetings, some informational, some deliberative, some placid, some tempestuous, exploring all of the possible ways in which international law might reach out to take in, to reclaim, to incorporate, to make part of the existing international intellectual property scheme, this set of knowledges and wisdoms which had previously been treated, for the most part, primarily as naturally occurring raw materials for somebody else's intellectual or technological projects. And it is that tenure at WIPO in that capacity, which we are here to celebrate with him, since he has recently retired from that position. And we're also here to celebrate his book, out immediately, soon, in a few weeks, entitled The Journey to the WIPO Treaty on Genetic Resources and Associated Traditional Knowledge, Policy, Process, and People. Go to the website for the book and take a look. You'll learn more about its contents. You'll want, as I do, to get an early copy, but you will also read fantastic blurbs from a whole series of people who I would sort of characterize as engaged experts in the field, praising him not only for his literary efforts, but for the extraordinary efforts that he has made over the years to keep this topic front and center, to make progress toward consensus, even when progress seemed impossible, and to advance the important cause that we all recognized way back when was so significant to address. How has he done it? Well, I have a few little lists here that may help to explain. First of all, he knows about a lot of stuff. His expertise in not only intellectual property, but cultural heritage law, the theory and practice of cultural diversity, biodiversity, multilateralism and international institutional governance, sustainable development. All of these are bodies of knowledge, fields of practice that he has mastered, and that his mastery of which has been then to service in the goal of promoting international consensus around these issues. It's really not the expertise that has mattered the most. It's not just the expertise that has allowed him to bring this treaty, the first conceivably of several, across the finish line when many thought that it would never take place. It's also his personal characteristics and the way that he has related over a quarter century to the various other participants in this important process. He has been, as I say, a respected expert. He's also been an exceptionally skilled convener and moderator of convenings with a skill set along those lines, which I have really never seen equaled or surpassed. He is an eloquent listener, if I may put it that way, an honest broker, and to everyone involved in this process on every side of these often divisive issues, a trusted friend. And I'm pleased to say that he's also a friend of mine and a friend of the program. And to welcome him to this podium for his talk tonight. Then?
It was at 2:34 a.m. in the morning on Friday, May 24 last year, that the gavel fell and the treaty was adopted by consensus. The WIPO conference hall, packed to the rafters despite the hour, erupted in cheers, and there were also tears of joy. Since then, the treaty has been described by countries, indigenous peoples, and commentators alike as historic, a win for greater balance in the IP system, in IP politics, a landmark, a breakthrough, a major achievement, an historic milestone, and a stark signal of the strength of the multilateral system. At the conclusion of the diplomatic conference, this is the conference at which the treaty was adopted, Brazil, speaking for its region, had this to say: "The treaty is not just a document. It is a commitment to honor the wisdom of our ancestors and to ensure that this wisdom benefits all. It will be a guiding light towards mutual respect and equity, promising a legacy of transparency, efficiency, and equality for all to come. It's a true vessel of harmony and healing within the IP world." Indeed, the treaty is a paradigm shift in IP. Several factors contributed to this success. Time and chance played a role. After a 25-year journey, a policy window had opened, a resolution was due, and unrelated world events, the Russian invasion of Ukraine, led inadvertently to the decision to convene the conference at which the treaty was adopted. Now, I hear you in the back asking, but what are some of these paradigm shifting features? And let me mention a couple for you. The treaty is the first international intellectual property treaty for which the main proponents were developing countries and indigenous peoples. For one of the first times in the history of international intellectual property lawmaking, they were not policy takers, but policy makers. The treaty responds to their 25-year-long call for the patent system to contribute towards the conservation of biodiversity, the equitable sharing of its benefits, and the combating of biopiracy. The treaty does so through the landmark introduction of a new disclosure requirement for patent applicants. And this is a step towards reconciling goals that were always thought to be irreconcilable. On the one hand, the promotion of investment in innovation through the incentives provided by the patent system, and on the other, the conservation of biodiversity and the equitable sharing of its benefits. This new obligation should lead to greater transparency about the commercial use of a country's biodiversity and what benefits are being created and for whom, triggering inquiries into whether national access and benefit sharing regimes are being complied with. And if not, this information could lead to benefit sharing that might not otherwise have occurred. Provider countries and indigenous peoples may then stand to gain a greater share of the monetary and non-monetary benefits that arise from the use of their resources. And in this way, the treaty contributes to environmental and economic justice. This new transparency requirement, which essentially addresses an asymmetry at the heart of biopiracy, will also help to reduce uncertainty about patents over bio-based inventions. This will lead to higher quality of patents and greater confidence in the patent system. And in this way, the treaty contributes to improving the efficacy, transparency, and quality of the patent system. The process that led to the treaty's adoption was also a model of openness, transparency, and inclusivity. In particular, for the first time in intellectual property standard setting, indigenous peoples had a seat at the table. As a result, it is the first intellectual property treaty to refer explicitly to indigenous peoples and to validate their critical roles as stewards of biodiversity and as custodians of precious bio-knowledge. Language proposed by them resonates throughout the text. They will play a role in the treaty's implementation and establishing conditions for a new partnership between states and indigenous peoples. In this way, the treaty contributes to social justice and procedural equity. And finally, in its absorption of new claims and new claimants, the treaty's adoption shows the IP system is capable of evolution. For decades, a few industrialized countries, the USA in particular, and industry associations representing the pharmaceutical, agrochemical, plant sciences, and biotech sectors fought against the introduction of a new requirement as is now in the treaty. However, with patience, persistence, and perseverance, other countries could achieve an outcome many had thought impossible. After all, the forum within WIPO in which these issues were discussed for many, many years, as Peter has mentioned, the IGC, was never even designed to produce any outcomes. The IGC's journey since 2001 comprised several setbacks and false dawns, plot twists, proposals laced with tripwire, ritualized exchanges of well-known positions, and missed opportunities. It was a grinding test of endurance. Yet it was also a slow gathering of small victories, relentless tenacity by several negotiator athletes, the forging of critical partnerships, and a gradual shift from competition to collaboration, from exchanging positions to joint problem solving. There were years and years in which no progress was made. Then the wave broke, and years of progress happened in a few short weeks and months. As you can tell, I'm a big fan of the treaty. However, I'm not suggesting the treaty is perfect. It's modest in many ways. It does not recognize TK as a form of IP. It does not establish any new rights in TK. And nor does it directly ensure that countries of origin and indigenous peoples are compensated. The treaty is silent on some issues and vague and ambiguous on others. But it was what could be agreed by consensus by all of WIPO's 193 member states at that time. It was this pragmatism, this modesty, this balance that after a 25-year struggle enabled the adoption of the treaty by consensus. To borrow from Tolstoy, the wolves are fed, yet the sheep are safe. To sum up on this part, the treaty's adoption is an historic step forward in the long and ongoing battle for the soul of the IP system. The treaty is at very least a platform for a conversation about the future of IP, a conversation in which new stakeholders will be at the table. And it's for all of these reasons and others that the treaty's adoption matters, both for what the treaty says and what the treaty means and how it was agreed. And this is one of the messages I'd like to leave with you. However, the treaty's importance should not lie in its adoption alone. The treaty's true effectiveness and usefulness in practice, whether it actually achieves its objectives and whether it's successful, in quotes or not, will depend on many factors and only time will tell. First, however, the treaty needs to come into force. And to do so, 15 countries must ratify or accede to it. I'm sorry to say, but there are unfortunately some signs that the treaty might not come into force as soon as many expect and might not have the wide membership as many had hoped for, including myself. There's maybe a risk that the treaty's adoption might end up meaning more than the treaty does in practice itself. And this would mean the treaty is less of a paradigm shift and more of a flash in the pan. And that'll be a big pity. In what follows, I'm going to ask you to think about the metrics by which the success of a treaty is measured, can be measured, and share with you some of those worrying signs that I've seen and end up with some ideas for next steps. But first, some history. In the words of Oliver Wendell Holmes Jr., a page of history is worth a pound of logic. Let's look briefly at the treaty's origin story. And this, of course, is a thinly veiled reason for me to acknowledge and honor Professor Peter Yazzie, whom we are with here tonight. And we're honoring you, Peter. And this gives me a good excuse to circle back to you. The treaty's origins are many and varied. I'll mention three. First, they lie in the new environmental principles and rules related to access and benefit sharing in biodiversity that were framed in a new convention, the CBD, adopted in 1992, and a protocol to that convention, the Nagoya Protocol, adopted in 2010. The treaty's most important feature, the tallest pole in the tent, as I've mentioned already, is a response to concerns about biopiracy amidst differing views on biotechnology and biodiversity, which one eminent scholar, Charles McManus, once referred to as one of the great questions of our time. Second, the treaty's origins go back to the long overdue recognition, starting from the early 1980s and culminating finally in a UN declaration of 2007 of the specific rights under international law of indigenous peoples. And thirdly, the early 1990s saw growing public debate and competing ideas about how the knowledge society should be governed. At the root of that debate was a fundamental question, or is a fundamental question. In a globalizing world, what should be the governance architecture and rules for the generation, use, and regulation of technology and knowledge, information, and culture? Following the adoption of the TRIPS Agreement in 1994, the logic advanced by industrialized countries that stronger domestic IP protection was a pathway for the advancement of all countries was increasingly placed in doubt. Changes were underway at WIPO too. We're talking now mid-1990s. Towards the end of 1997, Camille Idris from Sudan had just become the new Director General of WIPO. Idris was sensitive to the external events I've touched on, in particular, growing doubts about IP and of the role of WIPO, the emerging indigenous peoples movement, and the adoption of TRIPS in 1994, which was a formidable challenge to WIPO's prominence in global IP governance. In contrast to the isolationism of his predecessor, Arpad Bosch, Idris wished WIPO to engage more openly and constructively and address the role of IP in new and diverse areas. As the organization's first Director General from Africa and from the Global South, he was especially keen to legitimize the organization and the IP system in their eyes. Progressive scholars were active and influential too. And here I turn to Peter. As negotiations on what would become TRIPS were nearing the end, the Bellagio Declaration of 1993 included the following passage. Increasingly, traditional knowledge, folk lore, genetic material, and native medical knowledge flow out of their countries of origin, unprotected by IP, while works from industrialized countries flow in, well protected by the IP system, backed by the threat of trade sanctions. One of the signatories, and no doubt one of the most influential drafters of that declaration, was Peter. And so Peter is also part of the origin story of the treaty, one of the many fathers of the treaty. I first met Peter in 1997. He won't remember the meeting. I remember it like it was yesterday. I was in awe of him. I still am, Peter. And it's funny to hear from Christine that she'd been influenced by an article he'd written. I had just read and was deeply affected by an article entitled The Ethical Reaches of Authorship, which he had published, you had published in 1996 with Martha Woodmansee, and I still have my dog-eared copy in my study. As you mentioned, I was then a youngish IP lawyer, newly hired by WIPO. And in 2017, exactly 20 years after we met, I invited Peter to deliver the keynote address at an international seminar we organized at WIPO. And the topic I gave Peter was which gaps in relation to TCEs or cultural expressions, which gaps are there in the current international IP system and which should be filled and which should not be filled. And there was a fascinating discussion that followed, and the question remains today very, very topical. Thank you, Peter, for your contributions to this topic over all the years, and in particular for having been one of my influential inspirations and for your kind words in the beginning as well. It's much appreciated. I'm really moved to have been invited to deliver this lecture in your honor, Peter, and my warm thanks to Christine for the invitation. And to Taniat, Divine, Meredith, and Elena for all the assistance in my getting here. Now, back to the treaty and how do we measure a treaty success or otherwise? And I'd love to know what you think maybe afterwards at the reception. I'm going to suggest four indicators. First, a treaty's success could be measured by how many countries and also which countries join the treaty. Secondly, the treaty's success may depend on how effectively it meets its objectives, and this depends, of course, on how it is interpreted, incorporated in domestic legal systems, made operational, and enforced in practice. A treaty's success might thirdly derive from the extent to which it creates space for modifying other knowledge governance regimes, including the influence it has over the future evolution of the IP system. Fourth, and finally, on my little list, success may also be measured by if and how the treaty changes how people act, irrespective of when and where it formally comes into force. The treaty might, for example, nudge research institutions, biotech companies, and patent applicants to conduct their activities differently, even in countries that do not formally join the treaty. the treaty could become a de facto standard before it becomes a legal one. As the treaty is not yet in force and there's no experience with it, it's too soon to judge whether it will ultimately achieve its objectives and be a success. Only time will tell. Insofar as its coming into force is concerned, what do we know so far? 2 countries have so far ratified the treaty, Malawi and Uganda. 44 countries signed the treaty within the 1 year. There was 1 year to sign the treaty. 44 countries have signed the treaty. Of those, 24 are from Africa, 10 from Latin America, and 3 are from Asia. 2 developed countries have also signed, and this is really great news, Australia and Switzerland. And they both indicated that they have plans to ratify the treaty. That's great news. Of the big mega diverse countries, Brazil, Indonesia, South Africa, and the Andean countries have all signed the treaty. And this is a picture actually of the ambassador of Brazil signing the treaty on the last day. He also presided over the conference, and he's signing the treaty on behalf of his country at the end of the conference. India and China did not sign the treaty within the 1 year deadline, although this doesn't mean that they can't accede to it at some point in the future. And on the other hand, the USA, Japan, and the Republic of Korea have come out against the treaty. For example, at the most recent WIPO assembly held in July, the then acting head of the USPTO, I think that the director has now been appointed literally a week ago, but the then acting director at the USPTO expressed views that were against the treaty in relation to its integration into the PCT. After the treaty's adoption and upon its invitation, the USPTO has received 99 submissions, mainly from industry associations in the US and at least one from Japan. And these associations were all very similar to those that had provided submissions before the conference was held. And they all strongly discouraged the USA from joining the treaty. I'm not clear where the EU stands. At the conclusion of the conference, the EU seemed satisfied with the contents of the treaty, but was disappointed by the voting rights it would have in the future assembly. If the EU were not to join, it would be a great pity, in my view. The EU played a significant bridge-building role, not only at the conference itself, but in the years leading up to it as well. There are even indications that some of the big, mega diverse developing countries might not join the treaty. And why might this be? Of course, I don't know for sure. I'm just thinking aloud. First, the prominence that the treaty gives to indigenous peoples is for some countries a problem, because not all countries recognize that concept. Secondly, some countries already have a disclosure regime in their national legal systems. Their joining the treaty might require them to amend their national laws, even water their national laws down slightly, and that might also be a disincentive for them to join the treaty. I note, for example, that the relatively new IP protocol to the African Continental Free Trade Agreement goes beyond what is in the treaty. Third, the treaty does not directly require compliance with the access and benefit sharing regimes, which I mentioned earlier, which is a core aspiration of many countries. And nor, as we know, does the treaty establish any new rights. It introduces a transparency measure in patent procedure. It doesn't change patent law. And fourth, countries might come under pressure from their trading partners not to join the treaty or not to implement it fully. I see, for example, that the recent UK-India Free Trade Agreement, which was, I think, penned in July this year, so quite recently, falls short of including meaningful or new obligations along the lines of the treaty. Insofar as influencing the future evolution of the IP system is concerned, there we also have some early data that we can look at. The treaty has entered the work of the WIPO Advisory Committee on Enforcement. There's a treaty-related project or agenda item in the so-called ACE, Committee of WIPO. And as you all know, I'm sure by now, there's an optional disclosure obligation or optional disclosure measure in the Design Law Treaty adopted in Riyadh in November of last year. However, and I was very disappointed about this, an attempt in February of this year to begin working on making the necessary adjustments to the international patent filing system, in particular the Patent Cooperation Treaty, the PCT, was rebuffed by industrialized countries. Outside of WIPO, the treaty's adoption has ignited a flurry of proposals in the WTO. An especially interesting question is whether and how the treaty might influence the ongoing negotiations at WIPO in the same IGC on the protection of TK and cultural expressions, or TCEs, formerly known as expressions of folklore. For the protection of TK and TCEs, as Peter Yu has asked, is the treaty the end of the beginning or the beginning of the end? His adoption has certainly raised expectations, but I would suggest that IGC participants draw the right lessons from the GRATK treaty. Its adoption was due to unique circumstances and provides a limited template for if and how the IGC is likely to move ahead on TK and TCEs. The TK and TCEs discourse is very differently textured. The issues are different, the nature of the proposed solutions is different, and the political dynamics and alignments are also different. This is my second message this evening. The protection of TK and TCEs is a much more complex project. Proponents of new instruments on TK and TCEs should analyze closely why and how the consensual adoption of a treaty on genetic resources and associated TK in May 2024 was made possible. And I think that they should conclude that for TK and TCEs, a rinse and repeat approach is unlikely to work. The IGC sessions since the treaty's adoption have not been encouraging, with an awkward co-chair arrangement and a broken working methodology. Neither IGC 49 in December 2024 nor IGC 50 in March 2025 were able to make progress. The IGC is in a rut and seems to be working by rote. Its over-lawyered and ambiguous mandate and complicated working methodology have not changed much in many, many years and are no longer fit for purpose. The cluttered texts on TK and TCEs are now obstacles to progress. I'm pleased, however, to say that the recently adopted mandate of the IGC for 2026-2027, that's the next biennium coming up, shows some good improvements. The success of the new mandate, however, will depend on expert and thoughtful stewardship of the process by a team of very skilled and knowledgeable chairs, vice chairs, facilitators, and friends of the chair or chairs. To end with what's next. As you know by now, that I think the most immediate need is for the treaty to come into force. Why is this important? Once it does so, as patent applications covered by the treaty are processed, it will become possible over time to assess the treaty's practical utility and effect. Second, the treaty's assembly will begin to meet. The assembly will perform the functions assigned to it by the treaty, including starting to address the, I think, very important Article 6 on databases. And third, once the treaty takes effect, the timer starts ticking towards the critical review of the treaty under Article 8. Indeed, the treaty is not trapped in amber. It is future-proofed through the strategic review mechanism in Article 8. And if you're interested, I cover all these topics in a book that Peter has kindly mentioned that's coming out in a few weeks. In closing, the treaty's adoption on May 24, 2024 was a momentous milestone in the evolution of the IP system. Negotiators made history that day. It's, however, critical that the treaty's paradigm-shifting political and symbolic importance be matched by its practical effectiveness and usefulness. I'm reminded of Louis MacNeice's poem, Prayer Before Birth, words from which might apply to the treaty. I am not yet born. Let them not make me a stone. Let them not spill me. It's now up to policymakers, patent officers, patent applicants, indigenous peoples, and the world at large to bring the treaty to life. Thank you very much.
Some of us in the room were involved with the Marrakesh Treaty, which by all reports has been extremely successful in terms of how quickly it entered into force and the number of countries that have joined it, and then the number of countries that have actually implemented it. And so I was wondering if you could provide some sense of why you don't think the road forward will be as smooth for this treaty as it was for Marrakesh. Not that it's been smooth with Marrakesh, but it seems you're saying it will be less smooth.
Yeah, so Marrakesh is one which we look at to compare the two because they're not the same topic, of course, but they're a little bit similar in a sense. So Marrakesh, I think, required 30 ratifications to come into force. Correct? Or was it 20? 20. It did come into force very quickly, I think within 2 or 3 years. Our treaty, or this treaty, requires only 15. And so judging by Marrakesh, one would have thought this treaty would come into force also fairly quickly. It was adopted in May of last year. So what is that? Is that 18 months ago? Not quite, but getting there. 2 ratifications so far. A number of countries speaking out against the treaty. I've mentioned who those countries are. So I'm a little bit. I'm not overly optimistic. I think the treaty will come into force. Let me just be perfectly clear on that. I'm not suggesting the treaty will remain on the shelf. I think it will come into force. I'm just not expecting it to come into force as quickly as I had hoped. And Marrakesh was kind of an example of what I was looking for and looking at. So we are now towards the end of 2025, and I think maybe it'll come into force by 2027. So that'll be 2 or 3 years after adoption. Yeah.
The mere fact that the diplomatic conference was successful, it seems to have moved a lot of other negotiations forward. I know as you know, the WHO now has a project to adopt a policy on traditional medicine, and in the RFP they sent out about that, they went in some detail about the new WIPO treaty, and I think it's pretty clear that was an important factor in them thinking they had to solidify their thinking and start implementing policies relating to disclosures.
The treaty is being spoken about all over, and WHO is one example. It's come up in the CBD, the Convention on Biological Diversity, as well as you probably all know. In the WTO, I did mention that there's been a whole host of new proposals coming to the WTO since the adoption of the treaty. So it's very exciting to see the treaty is resonating throughout WIPO, I've mentioned already, and outside of WIPO too.
When I asked you what you were going to do to retirement, you said, I'm going to write a book. So you retired in what, May or June, and now we have a book next month. So it's now fair game.
I type fast.
I know how to type. So you're fair game to ask this question. What's next?
For me?
Yes.
I don't know, Susan. I retired, is it 3 months ago? Time has flown by. I've been pretty busy. I have a new puppy, so that's taking up a lot of my time. And doing lectures like this, of course. I'm not thinking beyond the book. So the book comes out in November. That'll be the last time I mention the book. I can assure you. And I'm not thinking beyond the book at this stage. So I have no ideas, no plans.
So with that, can we please thank our lecturer, Ben Bentley,